Hi, I'm Debbie Moraes. Once again, welcome to Legal Matters, the program that has been designed to address critical, contentious, controversial issues that are facing consumers and businesses today. It's legal information, practical solution, and straight talk about a wide variety of issues that affect your work and home life. Once again, we welcome Jackie Grasso and David Bazar from Audette, Bazar, Cordeiro, Grasso law firm in East Providence, who sponsor the show. I'm sorry. It's a phrase that's difficult for many people to utter. Early on, parents teach their children the value of saying it. They often encourage them to use it as they are growing older and in school. And then they also understand that at times that means forgiveness comes along with it. Few would argue that there's inherent value in that. It also goes a long way to improve relationships. That is, unless there's some sort of a legal issue or maybe an insurance issue on the table. So good faith and sincere apologies are viewed differently by the law and sometimes by insurance company. A doctor who apologizes for a bad outcome might be construed as admitting responsibility, guilt, blame, and likely to be liable for a lawsuit, malpractice lawsuit. So right now, legislation letting doctors apologize for mistakes without fear of being sued is our starting point today, and very specifically, the references to the James Wood's case with the death of his brother Michael. So James Wood is championing the idea that a doctor's "I'm sorry" should be allowed without terrible, dire consequences. He believes that that'll go a long way to improve the doctor-patient relationship, and it sounds logical and reasonable. So if you remember, in 2006, the little background story is that Michael, James Wood's brother, died of a heart attack at Kent County. Wood sued the hospital, accusing the emergency room staff for not doing enough to save his brother's life. And then he settled it before it was finished because the CEO, the executive, agreed to start an institute in Michael Wood's name, and she apologized. So, Jackie, David, it sounds good. What are the issues? What are your issues about them having an apology not being admissible in court for malpractice?
Well, we can start, I guess, in a number of different areas. The first issue is whether or not you even need a law to say you're sorry. I know it's not love story, but love means never having to say you're sorry.
I was expecting you to say that, David.
Yeah, I knew you would be. But the truth of the matter is a doctor could apologize and not really admit fault for anything in this sense. Medical malpractice requires a doctor to deviate from the standard of care. If a doctor deviates from the standard of care and that reasonably causes, if you can prove that it's causally related to somebody's death or injury, then there's a claim. But to say I'm sorry because there was a bad outcome doesn't mean you're apologizing for having done something you're wrong. You're just being a person and you're apologizing because somebody else has suffered a loss. So first of all, I question a little bit whether or not you need a law to say that it's okay to say you're sorry. What the law is designed to do is to keep lawyers from using that apology as an admission of fault. I guess it depends how that apology is phrased.
It's like settlement negotiations. When you're in settlement negotiations, you don't want to, you always have an agreement that anything said on paper in negotiations is not going to be admissible in court.
By rules of practice, settlement negotiations are not admissible at a trial before a jury.
So I think what David's saying is equating it to that with the I'm sorry law.
In some ways. Yeah. And I'm also saying this, that we have a couple of different rules in Rhode Island, one of which is subsequent remedial repair. Somebody gets hurt, and when they get hurt, the thing that caused the injury is the fault of the person that then goes out and fixes it. And you can then show that repair later as evidence of negligence. Well, that's an important thing on many levels. There's some public policy reasons why insurance companies wouldn't want you to be able to do that. But this I'm sorry law doesn't really equate to that. You're not apologizing necessarily for having done something wrong.
Yet there's been enough of an issue about this, apparently, that 36 states now have what they call an apology law on the books, which means right now if a doctor says, I'm sorry, it can't be used as fodder for the legal case, for the malpractice case. So if you have a doctor who is working with you or who's on the needs to be defended, so to speak, are you likely to have said to him, well, it wasn't that you said I'm sorry, but it's how you say I'm sorry? Is it, I'm sorry that you are suffering or in pain or that there was a bad outcome? And should he then say also, not that we did anything wrong, sir, miss, or whatever, do they need to qualify that so it doesn't give someone else a reason to say, aha, gotcha?
Without the law, I would suppose that's the case. And I don't think a lawyer should this is the other side of the same equation. I don't think a lawyer should build his malpractice case against a doctor based on whether or not he apologizes. The malpractice case is based on the evidence as to whether or not the doctor deviated from the standard of care. A lawyer still has to go to court and prove his case, regardless of whether the doctor's apologized or not. So do we make it such that without this law, a doctor would have to qualify his apology? Perhaps. But more importantly, I think the whole idea of what they're talking about is many people who have had a bad outcome happen, either to them, if it's their case, or if it's a death to the family members, simply are looking for some acknowledgement from the doctor of what happened. Be a person.
Empathy?
Empathy. And show that empathy. It's humanistic medicine. It's being able to reach and touch the person you're treating or their family.
Sounds so reasonable. The other side of it is I've read, and I guess it makes sense, that the critics of these supposed apologies laws are concerned that that sympathetic statement might then become empty or too self-serving and might then lead doctors to do it more often with the hope that they then won't be called on the carpet because people will be more forgiving and not want to press charges, and in the long run not necessarily help the doctors do a better job or do the right thing the next time. Are you concerned about that from a legal perspective?
I would be concerned somewhat, yeah. I think I would be concerned somewhat about that because, you know, the I'm sorry just intimates that they've done something wrong, as David said, and having to disclose that, having to use that in a case, it could definitely affect the outcome of a case.
And here's part of that. The law, the proponents of the law say there'll be less lawsuits if people apologize or are able to apologize.
Well, that's not going to be the situation.
It may be, it may not be, but certainly if it's representative of a doctor really having a good relationship with the patient and the family, and or the family depending on the outcome, because he really cares about them,
yes,
that's going to have an effect on whether or not someone wants to bring a lawsuit against the doctor.
What you're saying sounds so reasonable. In fact, though, to your point, studies are already showing that there are the number of medical malpractice claims decrease actually when doctors are likely to apologize and are more forthcoming when there's some sort of a negative outcome. So why would you ever want, if that's the case, why would you ever want to keep doctors under this shroud of secrecy, other than the fact that if there are fewer lawsuits, then that means there are fewer lawyers making money. I'm sorry, but we need to say that.
That's okay. And it's really, to me, more about medicine than it is about lawsuits. And the best part of the law for me would be if it made a doctor more concerned and feeling about his patient than otherwise. What I'm trying to say is I don't think you need a law for that to happen. I think doctors should be able to do that anyway. But if the law had that effect, then I think maybe it would help make medicine better.
Maybe the objective would be to decrease medical malpractice, but it could also be to bring people to the table much more sooner in the litigation process, right, rather than have to go the entire length of a case, because a malpractice case could take about 3 to 5 years sometimes,
right,
even longer.
And sometimes, well, in the case that brought this to light, Michael Woods and his brother James, they were just looking for the hospital to say, hey, we're sorry this happened. Mm-hmm. And would he have not brought the lawsuit then? Perhaps. I can't speak to that.
The some of the background, some of the stories were that when this initially happened, James Wood obviously was outraged. He was upset. And he said he was ready for thermonuclear war, I believe was the quote. And only when the CEO, Sandra Coletta, decided that she needed to have a one-on-one, face-to-face with him and said, I'm really sorry, clearly they had known that they were at fault and there were some issues. Now it starts to go to trial, or it is at trial, and they have the expert witnesses that say there was something about the standard of care, that it could have been prevented if this had been done, and I won't cite all of the specifics, but clearly there was reason for him to have a law case, a lawsuit.
Right.
But I think what happened in that case is it was the CEO that apologized during the trial. It wasn't
Yes.
prior to.
It was
during
during
Right, it was during.
And when they finally had a face-to-face meeting, that's when everything came to a resolution.
Yes.
And they
But-
settled the case without having to go to a jury.
Again, would that case have gone to suit or not if the hospital apologized up front? I don't know enough about it to answer that. However, the cases you were talking about really wasn't based on whether or not the hospital had apologized or didn't apologize. The case was based on the experts and the care that was given.
Yes. Yes.
And that's true of any case, whether they apologize or don't apologize. You still need to prove your case.
And as lawyers, when you are talking to your clients, don't you generally say to them, you don't need to say anything more than you actually need to say when you're in a trial, when you're being cross-examined or whatever? How much really needed to be said at a given point? I imagine that those good PR say what you need to say and nothing more. You can bet that all hospitals are reticent about saying, we did this, or we screwed up, we operated on the wrong side of the brain, or took off the wrong foot. You understand that they wouldn't want to say that unless they had to, but don't you generally caution your clients to not say more than they absolutely have to?
Well, I think we have an obligation to do that.
Right. After a case is already in suit
That's
and your
right.
client's undergoing a deposition, what we tell our clients is three things, generally. One, tell the truth.
Mm-hmm.
Two, listen to the question and answer the question. Don't volunteer information. And three, tell the truth.
That's good, 1, 2, and 3. On a related note, is the more pressing problem that's going on here, apart from James Wood's story, not simply the fact that there's a lack of apologies, but really a fundamental lack of disclosure? Not always or seldom are doctors and nurses and hospital administrators willing to sit down and have a discussion about all the pros and cons of what went on, anything that might have gone askew. There's generally not disclosure, even in the patient visiting the doctor in his office. Is disclosure overall an issue, and what should we do about it?
Well, you're starting to hear a lot more about disclosure. What comes to mind recently is a wrong side surgery that happened in Rhode Island Hospital,
Yes.
and also I think it was Roger Williams Hospital. Either way, but the disclosure issue, I think the legalities behind that, probably it could be the insurance, the malpractice companies that maybe have an issue with disclosing.
It's a little bit different than the apology, because the apology is really being a person who cares about another person. The disclosure part of it, the insurance company is now probably going to have a problem with that. And I don't think at any point in time that what is disclosed to somebody as to what happened should ever be not admissible like the apology would be, because it's part of the case. And if they say, well, here's what happened, here's where we went wrong, here's all the mistakes we made, but since we told you, you can't use that in your lawsuit, that's never going to be the case. And it's not where the law is going on that.
Should we talk a little bit about tort reform? I mean, the punitive damages go on, and certainly we understand that there's a very high cost of health care. There are so many issues about a doctor who opens his office, his practice. He's got his education costs, his office costs. He's got insurance premiums that are skyrocketing, and of course a lot of it, depending on the risk of his practice and what his specialty is, that's an awful lot of money to shell out. Couldn't we cap it if we had some sort of way of capping that? I know you don't like tort
There are some
reform
states that do
discussions,
put a cap on your damages.
Okay.
Okay, Rhode Island is not one of them. I know that there has been talk about having a cap on the damages.
And it's about the worst thing you could ever do to somebody.
right.
Because?
For several reasons. First of all, punitive damages don't really apply in medical malpractice cases at all. I mean, perhaps...
Maybe we should explain what
punitive damages are to
they'll
punish somebody for repeated action or something that they've done almost intentionally or outrageously or recklessly in some form or fashion. Exxon, I think, is the biggest punitive damages case in Texas, and whatever they did was so outrageous, there was a big punitive damage award, and it was designed to punish. The problem with capping damages is, and there's a number of different ways of capping them, someone who is truly injured and deserves to be compensated needs and should be compensated, because who is that burden going to fall on? The state? The federal government? There's going to be need and care that somebody who's caused wrong to somebody else now has to get. And if you cap their medical damages, their those are the economic damages, or the pain and suffering, the loss of life and whatever it is, you've really put the burden on one person, instead of having it shared across, as insurance is designed to do, the broad spectrum of everybody who
Also, the
pays
misconception out in the public is that it's lawyers that cause malpractice rates to increase, when in fact that's not the case. You
Right.
know,
Good
and
venue to
perhaps maybe
explain.
you should have a conversation with my husband, who researched this issue and who was a state rep, but he did find that there's a very small percentage. The litigation only relates to a small percentage in the increase or the cost of malpractice rates, but people automatically point their
Right.
fingers to
And
the legal.
Towards that
Point
end,
well taken.
what's
Practice.
most telling is
Yeah.
those states that have tort reform and capped damages, their premiums are no less. In fact, in many cases, sometimes more than states where there hasn't been tort reform or caps on damages.
Interesting. Good point.
And
You
of course, just on that, people who don't know what it's all about and say, oh yeah, cap damages, it's not legal lottery or whatever else, that is really good until they find out they get hurt and it applies to them.
Right, and when you mention that, and it's a very good point to make in view of James Wood's case, because clearly he is not disadvantaged economically. So he doesn't really do this because he needs the money, where most other people, he can afford to be magnanimous, maybe even somebody might say tongue-in-cheek, big shot, he can be very magnanimous. Other people don't have the luxury and might actually be suffering the economic loss that is significant apart from the loss and
Right.
pain and suffering that went on.
In this case, though, and I don't remember it entirely, but it's my recollection that there were children of his brother, nieces or nephews or whatever, who didn't have economic advantage, if you will. And as a result of the loss of their father, there was some payment made for them because of the loss that they suffered.
I know he had a fiancée. What about the situation where it might cut the other way? Somebody apologizes for something that went wrong on that operating table, or there's a loss. How do you feel about the fact that, say in James Wood's case, he calls off the dogs? There's a settlement. Does it make you think that this apology law, as it's happening maybe in Rhode Island and has in 36 other states, that they're less likely to award a higher amount of money because the doctor has said, I'm sorry, or the hospital has said, I'm sorry?
I don't think
Do you
so.
have any feeling about that?
I don't think so.
Well, didn't we just say that it was inadmissible under the law?
Yeah.
So
they wouldn't know about it.
They wouldn't know.
So they wouldn't
jury
know.
wouldn't know about it.
Well, if it already but if the trial had already started and they are suing for a certain amount of damages, or they think that there's a certain amount that would be assigned to it, and then there is that CEO intercepts it.
But the problem is you won't know what the jury's going to award. You don't even know
That's
if you're
right.
going to win your lawsuit. So you have to take the case all the way to conclusion. What they did in this case is they settled it in the middle of the trial.
midstream, yep.
So anybody, there could have been a result either way, beneficial or detrimental.
Right.
We wouldn't know if until the jury had reached a verdict on the case.
Apparently there's debate, too, about who's to blame. Is it the issue about, is it the one person who caused the problem, or is it about the system? Do you see that there should be any difference when an apology is made? I'm sorry that you lost your whatever. I didn't do wrong. Maybe the system did something wrong. Should there be some distinction that's made when the apology is being made and when a suit goes forth, do you need to make a distinction about whether it's the system's fault versus one individual's shortcomings, lack of skill, knowledge, or whatever?
Well, if I understand what you're saying, is the apology and then the qualification to the apology, I'm sorry, but I didn't do anything wrong, or I'm sorry, I didn't do anything wrong, but boy, the system really failed.
Yes, but the system really failed.
I
Is
think
there a
it really
distinction in your
depends
mind?
on the injury that was suffered,
Yeah, well,
how it happened.
It goes to what the lawyer would need to prove if there's malpractice. If the system is the problem, the doctor didn't do anything wrong, depending on what the system is, if there's a redress against that. For example, we talked a little bit about Jackie's mom's situation before, and that if Jackie's mom couldn't get to another doctor because of the system, who are we going to sue? There's
And
a
there's a
And
good
that's
example
exactly
of it.
what happened. It
Right.
was the system. Yeah.
So that debate is currently going on in various states about whether or not the doctor gets to say, I really, it wasn't our fault, but that system really isn't the way it should. We should have been able to do this, but it's beyond his specific lack of expertise or whatever, so he might be off the hook.
Maybe.
Maybe.
Depending on what that issue is.
To err is human. Doctors are human. I made a mistake. Suppose he actually did make a mistake, and you're his lawyer and you have to defend him. Should there be anything? What can you say to help that? Is there a good reason to say
It depends what the
you're just
mistake
human?
was. If it's a mistake that any doctor of his training is likely to have made, it's not a situation where a doctor that has the same training would never have made that mistake or a deviation from that standard of care. If he hasn't deviated from it, it's not malpractice. Things come out wrong. Things don't always happen the way you want them to happen. It's only when your care is such that it doesn't meet the standard of care of a doctor with your same training would have met that you have a malpractice claim.
This is why we have to have the use of experts, because we have to get that opinion from another doctor who has similar training and expertise.
Right. I mean, there's some cases that are just clear-cut, and there are others that...
Wrong side surgery is pretty easy.
Yeah.
For instance, like there are some surgeries that are very high risk, and one that comes to mind is the gastric bypass. That's a very high risk surgery, and then ultimately death can result. Does it mean that something went wrong? The patients have to be informed of the risks that are involved.
What can you actually say before there's a problem to a lawyer? If you have a lawyer, if you have a doctor who is a lawyer, needs a lawyer for other reasons, you have an occasion to speak with him. Do you really suggest that he should be forthcoming and explain and disclose as much as he can to his patient because it fosters a good, trusting relationship? Or would you say, need-to-know basis only? Do you have some thought about that?
It's just typical human nature. It's the doctor-patient relationship. If the doctor has a good bedside manner, then perhaps he'd be more forthcoming with his patient. It just depends on who it is.
And I think if you're a good doctor and you're confident in what you're
gonna do
doing,
that anyway.
you're going to have that relationship where you want to have as meaningful a discussion as you can with your patient for many reasons, not the least of which is so that they know exactly what you're doing and why. And the least of which is so that they like you and won't sue you.
Yes. And how about if it's not a matter about mal, as we're talking about those lawsuits, but if the doctor is your client and you are coaching him or you're dealing with him on various professional issues, he may or may not want to be self-disclosive because it may have other repercussions, and so disclosure ends up being another issue. For example, he could lose a little self-respect, self-esteem, maybe tarnish his reputation slightly for having fessed up to his seniors or to the administration. I don't know, perhaps even be fired. Can you protect him from being fired because he's self-disclosive? That's one step short of saying I'm sorry?
No, I don't think you can protect him from being fired. If he's fired, it's because he did something wrong.
Right. And if he's fired because of his relationship with the patient,
that's
and if
even
it's
worse.
an appropriate relationship, though, then, there may be some issues there. But again, I don't know what the relationship is with that doctor in the hospital and employment contracts and that type of thing.
When you think about the fact that this CEO, it was actually saying something quickly about what to do with the money that's going to be taken out. The CEO is saying we're going to be starting a foundation for, in Michael Wood's name. Do you think that that in and of itself in a lawsuit, had it gone forward, should that affect how much money is going to be awarded in a med malpractice suit?
I don't think it should. I think it's just, you know, it's a worthy cause for him to put some of the money aside for charity, but it shouldn't affect the outcome of the lawsuit. How you're using the money should not affect what you're going to be getting in damages.
And what do you think about the idea of disclosure in general? Are you likely to say, whether it's a doctor or some other professional, are you likely to advise or counsel them? I can speak from a PR standpoint, but from a legal standpoint, everything is about improving the conditions. Would you say that, whether it's a doctor or a dentist, that they're likely to have a better situation just by having conversations, more open conversations with patients?
Yeah, it does foster a better
I think
patient-doctor
it's
relationship.
true of any relationship. Yeah. It's doctors, dentists, lawyers, anybody where you need to have an honest and open dialogue with and have some trust with. That open dialogue helps create that trust.
You know, when you think about the situation of the system being at fault, would you ever find it to be a reasonable defense to say, well, I'm sorry we had the wrong site surgery that you referred to, but if the system allowed me to put a black magic marker on that foot, it couldn't have happened? Does someone get away with that?
No, because that's an industry practice. That's sort of what you're talking about.
Yes.
And if the practice, you can say, oh, I didn't deviate from the practice of the industry. That's what we do. That's what everyone who does this does. But that practice is wrong, then you can still bring a case. It's almost, I think we talked about this once with products liability. If everyone in the industry makes a bed out of bedding that's totally flammable, and they know that, and the industry standard is that's what we use, but there's another way of doing it that is safer, and they just don't do that, you're not going to be protected by saying I met the industry standard.
And if the industry standard isn't quite what it's supposed to be, and you're at trial and you're defending your lawyer, if he comes forth and says, and this didn't exactly play out the way we thought it could or should, but in the past month, obviously the case has been building up to this point, in the past month we've instituted these new practices, etc. What does that do for your case? Is that something you might suggest as a strategy? Is that something that holds water or merit?
That's the subsequent remedial measures that
Yes.
David was talking about. What does it do to your case? It depends on the state the case is coming in.
Right.
Does the state allow that in evidence to prove an acknowledgement of negligence? It just depends. You mean, could it make the case more valuable? Well, perhaps if you're in a state that allows that measure to come in as
Right.
evidence.
That's exactly correct.
And if it wasn't negligence, but just there's always a better way of doing things, and as a result of this, a bad outcome, we found a new and better way of doing it. Does that make a difference? If it's not negligence, but just an enhancement?
Well, I think it goes to whether or not they knew the old way was wrong.
So you're going to negligence again, or
Yeah,
not
yeah.
quite standard?
If the old way was
be?
negligent. I'll give you another example. We had a case once with grapes, and the way they used to display grapes is you'd pick them up and put them in a bag. And whenever you picked the bunch of grapes up, some always ended up on the floor. They knew that people were falling on those grapes all the time, so they started putting them in bags before you went to put them in your basket.
A reasonable and now a prophylactic measure of how to
Right.
make things better.
Right.
We wish everything were that simple. More on the apology laws as it's going forth in Rhode Island. There is something in Massachusetts heading your way too regarding the apologies laws. We thank you for tuning in. Jackie, David, we once again thank you for joining us. Please stay tuned as our discussion about legal matters continues.